So we talk about 9B. Then we talk about prosecutorial discretion update. You have that information.
Prosecutor, yes.
And then we talk about portability, mobility, H-1Bs and IVs also.
Actually, you know what? But that stuff on waivers and that stuff, provisional waivers now, and that stuff on, hi, how are you?
How are you?
Hi, good to see you.
Pleasure.
Hi, nice to see you. How are you doing?
This is for you.
Okay, thank you.
How is everything?
All
Your
right.
health is good?
Good,
You
yeah.
look good, you look so smart.
You know, what, can I get a pizza from here?
Huh?
Pizza for lunch?
Pizza?
There's one right around the corner.
Okay, let's have a pizza. Doctor's shop.
Yeah, I think we have to,
Welcome. Sure.
Good, yeah.
Let's order pizza.
Okay. Yeah, one
Thank
more
you
for-
so much.
One more 15 minutes, we'll be done. Before pizza comes, we'll be finished.
Okay.
Okay.
Thank you, doctor. Thank you.
You're welcome.
Thanks.
Anytime.
Now, and that stuff on, hi. So
Well,
why don't we do this? Why don't we, okay, so here's what I'm thinking.
No, but see, these are timely. We talk about
Here's-
CBP, we
right.
cut off dates.
Here's
That
what
is-
I'm, here's
they
what
cut
I'm
off date
thinking.
is to
The
go
first
for.
one that we did, here's what here's and that stuff on, hi.
The continuity doesn't change. See, my only concern is the continuity that we did when we talk more about the next India in the next program, for example.
Yeah, but that, you'll have that continuity.
In every program, we had up to 3 programs.
Oh, no, you're right.
Third one do the.
You're right, that's gonna be a
So
problem.
it's okay, it's timely, but it's nothing like urgent, because this is important, but not like a date expiration thing.
Let me just think, prosecutorial discretion, I can address it in very general terms.
Yeah,
I mean, we can actually use this one for May 20th.
yeah, that's what I'm saying.
Yeah.
Let's do on 20th.
Yeah, we can do it.
That's what I'm saying.
So this is May 20th, right?
Yeah,
Yeah, we can use, all right, so I'll gear this toward May 20th.
yeah. That's what I'm saying.
Yeah, but you're gonna have the May cutoff numbers by,
So
you know, the
they go
June
little
cutoff
June
numbers.
cutoff dates,
So
no.
we'll plan for
No, May cutoff dates.
last week in May to come here.
May cutoff dates will have to be little late.
Yeah, a little late. Okay, all right, so we'll make it work. Yeah, we're good. We'll make it work.
We
Okay,
can do a May and June too.
yeah.
We can do a
If we have to
combination.
come, we'll come again. It's,
Yeah,
yeah.
Okay, so 9B, then prosecutor discretion,
Mhm.
then portabilities, and then
Mobility.
mobility and portabilities.
Mobility. You can do them separately. Yeah,
Separately.
yeah.
And also a little bit about H-1Bs, when what happens when a H-1B employer all of a sudden
Terminate,
terminates.
absolutely.
So what are the obligations on the part of the employer?
Big questions I'm getting now are if someone is looking at an October 1st start date, can they be here on a B1 in between the time of before October 1st? That's a big question I'm getting for gap filling.
It's a very tricky because you
It
apply
is
for
tricky.
extension, it's denied,
It
there's
is.
serious problem.
It's tricky.
So I would not recommend that to
Well,
people.
it
To extend,
depends. It
apply for
depends on the
extension.
circumstances.
That's all.
Yeah.
Apply for extension, it's denied, you got a serious problem. Then his 10-year visa is cancelled,
Right.
then he'll have a
It's-
problem. I wouldn't recommend.
That's the question I'm getting, but, you
Yeah.
know, I'm just, okay.
No, but we can talk generally, you find you
Yeah,
can have
of
visa
course.
processing, no?
Yeah, of course.
You had lost your job, you cannot change this, but you can all do a visa processing. In a good case, and sometimes it's good to do that anyway, because after you change the status, and then you are going outside, the consuls are unhappy that you change the status,
Right.
always.
Right.
But you were nice, you maintained your status, you went back and applied for
You
H1.
did it the right way.
Yeah,
Exactly.
So they
That's
can
what I'm
talk about
telling
that.
them to do.
yeah, that's you can talk about that also,
Okay, yeah.
the time remaining.
Okay, perfect.
Okay.
Okay, sorry. We're good. I have to get back.
आपकी नजरों ने देखा प्यार के काम. He's talking a song to the heroine. He's saying that your eyes have seen me and found me worthy of your love. So what can I do now? So come on, come into my
What are you
arms.
gonna
Come
do?
into my arms. Let's not waste any time. He says, your eyes have seen me as worthy of my love.
Did you,
Ready?
Yeah.
yep,
Okay, let's go.
did you enjoy the? Now, and that stuff on high.
Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my partner David Nachman.
Thank you, Michael.
David, welcome.
Thank you.
Now we have been last 2-3 weeks we have been doing a lot of very good programs and giving the latest information and we hope that you have found all that information very useful. It will be nice if you can send us your emails to let us know how you find our programs and what other important subjects that you like us to cover on this program. We'll be more than happy to do so. Now with that, today's program, we want to start with an interesting court decision that just came recently. Now many of our people that stayed unlawful status here in the US but were eligible to apply under section 245I or under 245A, it were married to a US citizen or anything, and the 485 application is pending now in the Immigration Service. There comes an emergency. The father is sick, mother is sick, they just get an advance parole, which is a permission to travel, and then go back to India and come back. When they come back, the law, as it was interpreted previous to this court decision, says that you are subject to a 10-year bar because you remain illegally in the US for more than 1 year. And that has been a big problem, even though the Immigration Service have been giving you the advance parole, and to some extent we did put a fault on Immigration Service. If I am not eligible, why did you give me a permission to travel? I mean, assume you are telling me it's okay for you, go travel if you want. They give advance parole permission to travel, even though in a little print there is some warning that if you remain illegally you may be subject. But many people don't even look at that. Lot of our people just got a paper in the hand, it's advance parole, they take a ticket and they fly. This court decisions makes a major change, and I'm going to ask David now, request him to explain to you what the decision is and how that affects that old policy.
Okay, well, Michael, first of all, I think what we want to do is point out the name of the case to our viewers, and this is the case of Yarrabelli. So it's the matter of Yarrabelli, and this was decided on April 17th of 2012.
I think these people are residents of India, if I'm not mistaken.
That could be. Yes, I was actually focused on the holding of the case, but it could be that they were.
Yeah, okay.
Yeah. And I think that probably the most important and relevant part of this decision is that, and it's kind of interesting, Michael, to me what this decision does is essentially finds a way for the court to justify, there's what's called an estoppel claim. Estoppel means that the government makes a representation or induces a person's reliance, and they act in a detrimental way when they've been induced. Their reliance has been induced. And so what essentially this case does is it rectifies a situation where individuals have traveled outside the United States on an advance parole travel document, then come back, and then all of a sudden found themselves in a position where they weren't allowed to take advantage of 245I.
First of all, I really thank these people. This has been going on for a while. We thank these people that had the courage, go to court, challenge the Immigration Service, and get a decision that is going to help many people.
That's right, and to take a case as far as they have. And many of our clients are not willing to take the cases that far. Many of our clients say, well, no, financially we can't handle it, and we can't do that. But obviously these people were willing to take the case all the way up and to get the court to make a good decision. So
It also
basically,
makes sense, as you were just saying. It makes sense. You are giving, here's the permission to travel, you can travel. So he says, okay, thank you
That's
very
right.
much, I'm going.
that's right.
When he comes back, he said, no, why did you travel? Now you are subject to 10-year bar.
That's right. The case is consistent with the tenets of estoppel, of equitable estoppel. And again, equitable estoppel means it's an equitable form of relief where if the government tells you something, then you should be able to rely upon that. And this case is consistent with that. I don't believe that in the determination there are allusions to equitable estoppel,
No,
but I
there are
believe that there
illusions,
are.
But I think that this interpretation of the word departure was the focus.
That's right.
Because the law
That's right.
says if you depart after remaining illegally in the US, if you depart, go outside. I used to tell people, if you 1 minute only go out, cross the border line, cross the Lakshman Rela for 1 minute, you are subject to a 10-year bar. Because the word departure was misinterpreted.
Right.
This judge was very nice. He says, brief casual trip abroad is not a departure if he's traveling with a permission to go and come back to resume your application 485. So this judge was very nice, interpreted correctly, and told the government that you were misapplying this section for this.
That's right. And Michael, actually, the case specifically refers to an individual who has traveled when they have an approved advance parole, they advance permission from the United States government on the basis of an application which has been approved, okay, and it presupposes the alien's authorization to return to an unrelinquished lawful permanent residence in the United States, or the ability to take up and preserving the alien's eligibility for adjustment of status.
I think this
So,
reminds us, of course, this is for the lawyers. There was a case in the past, many years ago.
Pre-1996.
Nice, Flutie
Right.
case, where the
Flutie,
judge says
exactly.
that, you know that amnesty program 1986, which said that if a person came before 1982 and has been living continuously in the United States, he can apply for amnesty.
Right.
And then some people who did travel even to Mexico for a week or 2 days, 3 days, came back. The immigration service took a position that that is a breaking of the continuity.
correct.
So therefore, these people are not eligible. And the court in the Flutie case says that if it's a brief, casual, and innocent departure, somebody went for 2 days, 3 days, father died, that should not be considered as breaking the continuity. And therefore, it is not a departure.
Right,
and
and
that's the
that's-
principle they applied in this case.
And pre-1996, the Flutie doctrine was prominent, and then because of the 1996 law, it called Flutie into question. Flutie, for our viewers who want to look this up on the internet, it's spelled F-L-E-U-T-I. It had to do with an individual who had, as Michael properly said, took a brief casual visit to Canada, and as a result of that, that was what was called into question, is whether or not the individual could return to an unrelinquished application for lawful permanent
There's a
residence in the
difference
United
in the
States.
Flutie is, in Flutie case, the person did not have a advance parole.
That's correct.
So in this case, they are only restricting to those cases where a person's applicant is pending, he gets a permission to travel,
Right.
and is coming back to resume his application for permanent.
That's correct. And in this case, basically what it is that the individual had relied to their detriment upon the fact that the advance parole document was issued to them, so they believed they had the ability to return to the United States to take up that unrelinquished.
No, there may be some
domicile.
cases, a piece of advice for our viewers, where these people applied for adjustment of status under section 245 or 245A, and the officer at the time of interview said you are subject to a 10-year bar, denied that application, and they were even ordered deported or whatever happened, and they are still here, may be able to make a motion to reopen this case based upon the court decision, to go back to say that this was wrongly done. And I mean, I don't know how the courts will decide, but I think a pretty good chance that even the government on their own, may agree to, we make a motion and they say, okay, because they will comply with the law. We see how the policies develop. But I think it's a good, if person, any of our viewers is in that position, or a pending interview is still pending, or the case is held up, or the person has applied for a waiver of a 10-year bar, that's also is okay. They no longer know that waiver is necessary, or that make easy for the waiver to be granted, or even without a waiver also the court says that is not a departure.
Exactly. Exactly.
So that's very good. If you, any of those type of cases you have, please feel free to contact us, send us an email, and we'll see that how we can help you on that. Let's move on to some other subject.
Okay, Michael, one of the areas that we've been receiving a lot of questions about, and interestingly, 3 questions came this week on what's called mobility under Section 106C.
Before that,
Yes,
David,
yeah.
sorry.
Okay.
We talk about 9B here.
Okay.
In the 9B context, now we talked about that this case, court case, in which these people, are not considered a 10-year bar because they had advance parole. So let us say somebody did not have advance parole. He went to India for visa processing and interview without getting the advance parole, or he was not in a position, he was not even eligible to file a 485, he just left.
Okay.
Now, there's a change in the law. The old law says that they had to go to the consul, get a denial, then apply for a waiver at the immigration service abroad. This is a change in the policy which permits a person to apply for an advance parole before going to home country, in advance getting that approved. Explain to our viewers about it.
Well, are you discussing the provisional waiver?
Yes.
The provisional
Yes.
waiver provisions. So as far as I know, the provisional waiver rules are out for, they've actually been published. So the Federal Register had listed
Published.
published the information about the provisional waivers. What it means is that individuals have the opportunity to know before they go whether or not there's a very high likelihood of the case being approved when they go outside the United
Correct.
States prior to visiting the U.S. Consulate and doing their
This is
green card
only on the
interview.
9B unlawful presence, not on the fraud or other categories.
That's correct. It's only 212A9, B sub 1 and sub 2, which are the 3 and the 10-year bars.
So basically, once again, a person, one of our viewers, he came illegally to this country, and he's now married to a U.S. citizen, and he cannot adjust because he's not, eligible under Section 245I, which is applying for a green card application or a labor certification before April 2001. So he goes to India for the interview. In the interview, the consul says, "You're fine, everything is okay, but sorry, I cannot give you the visa because you are subject to a 10-year bar."
Correct.
And then he applies for a waiver, and the waiver is denied in New Delhi. That person is stuck for 10 years. Now, under this new policy, what you just explained to our viewers, they can apply here in the US before going there.
That's correct.
If they apply here and the immigration approves that, then they are carrying their waiver with them, go to the consulate for interview. The consulate says the same thing, sorry, okay, but I have the waiver already. Now, most cases, if there's nothing else, then he can get the visa and come back. And wife is waiting, children are waiting here, everybody's happy.
Right.
But there's a caveat to that. Just be careful. In doing so, it is possible that the consul may dig further. If you came, let's say, without a visa, consul say, how without a visa? How did you go? How did you travel? Who helped you? In terms of whether you committed any, he's trying to find a point
Some
or
other-
some other reason,
Right,
a
exactly.
fraud or a
To
misrepresentation
deny
or
the
something.
provisional waiver.
And then if he can put that charge on you, then you have got a bigger problem. Because that waiver doesn't cover, the waiver you got in US only covers the 9B unlawful presence. It doesn't cover that other charge. Then you have to apply for a waiver in New Delhi.
That's right.
And then God knows what happens again. So be careful. I mean, it's a very good thing, but you have to be careful.
I think it's important for our viewers to know that this is out for rule making. It means that the public can submit comments. So I would encourage you to take a look at the rule. If that rule affects you and your particular circumstances, you, like any other person, any other member of the public, can submit a comment to the government. And the government obviously is interested in your comments so that when they make the rule, they're able to take into account all of the circumstances that could potentially affect you. So we recently had a meeting with the individuals who handle external affairs for the American Immigration Lawyers Association, and they encourage the public to submit as many possible comments as they can.
Thank you very much, David, and thank you all of you for watching the program as usual. We'll try to bring more and more and more important information on this program. Please keep watching us on ITV and Vision Avesha. Thank you very much for watching the program, and goodbye.